you know it's what I always wanted. Could never have too many things. Well, you quit kicking me under the table. I'm trying, will somebody make us shut up about it? Can we settle down,
Shalom, this is your Ark. Yah is magnified, coming back with another informative video. I titled this video, Sue the State in the State. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, let's get to it. So I already know, I've been coming on YouTube lately and bringing a bunch of bad news to a lot of people who just don't want to see this real truth, But like I stated before, I only bring the bad news to get you all ready for the good news. Sometimes you gotta destroy only to rebuild. You have to forget everything that you thought you knew, erase that, and start over again. Stop going with what you've been told and start going with what has been proven and what will be proven. Okay? So now, as you all can see on the screen, this is coming from OhioAttorneyGeneral.gov. Right? I didn't make this page up. As you all can see, I can stroll down through the whole page. I did not make this page up. This page is a creation of OhioAttorneyGeneral.gov. This is a governmental website. Okay? So now, as I stated before, if I tell you all not to sue in federal court and don't waste your time in federal court, why? Because there's no remedy there. Been there, done that, tried that. And so many others, been there, done that, tried that, got the same results. I tell you all to sue the state in the state. Why? Because that's who has jurisdiction over the matter. That who can waive their sovereign immunity. A state can waive its sovereign immunity when it's sued in the state. A state can hear suits against itself. Okay? The state has jurisdiction to do so. Federal courts do not have that jurisdiction. So, when you go to them federal courts, like I showed you on every reply back in a federal court lawsuit against a state and its agencies, they will tell you for these reasons why they will dismiss your claim. Failure to state a claim upon which relief can be granted, right? Sovereign immunity, and a state is not a person underneath 1983. The same three claims over and over and over again. So now, once we make those failures multiple times and you see everybody losing, then you say, hey, hold up, man. We got to turn around and, do this thing over. Let's scratch that. That's not working. Let's try something new. Okay? What I'm about to show you all, you don't have to come through me to get this thing done. You don't have to go through nobody. You can do this on your own. Okay? Just make sure you follow the rules and civil procedures in your state, because every state has the same thing to make the state waive its immunity so you can bring a suit against it. Okay? But you must follow the proper rules of etiquette. Study your state rules and civil procedures before you make that determination. Okay? Don't just go in there filing a bunch of nonsense and thinking you're going to get a lawsuit and the state going to waive its immunity. No, it's steps to this process. But I'm going to show you all that the state can be sued in the state. Okay? And we're coming from the Attorney General in the state of Ohio. I didn't make this up. These are facts. I told you I only deal with facts. Okay? That's it. That's all. So now, let's stroll down. Courts of claims, defenses. But we're not going to pick it up right here. If you all want, you can pause. Hold on. Let me zoom out a little bit so you can pause the video. Hold on. Zoom out some more. Pause the video and y'all can read, the opening. But I want to get straight to the meat and potatoes. So we're going to go to general provisions, right? General provisions. It states, prior to 1975, the state could not be sued for damages unless the legislator specifically authorized the claim. State employees were also immune as long as they were acting within the scope of their employment. However, in 1975, the Ohio General Assembly, pursuant to its authority under Article 1, Section 16 of the Ohio Constitution, enacted Ohio Revised Code, ORC, Chapter 2743, establishing the courts of claims, in which the state could be sued for money damages and the immunity of state employees could be determined. That's what you want to hear when you bringing a claim into a court. But let's continue. ORC 2743.02A1 provides that the state waives its immunity from liability and consents to be sued and have its liability determined in the courts of claim, created in this chapter in accordance with the same rules of law applicable to suits between private parties. Okay? But let's continue. Generally, the courts of claim is vested with original jurisdiction to hear and determine all civil lawsuits for money damages filed against the state of Ohio. Not the federal government. Okay? The state of Ohio has jurisdiction to determine all civil suits for money damages filed against the state of Ohio. In what court? The courts of claims is a state-created court. Don't deal with the federal. I keep telling you over and over and over again, but let's continue. However, the Courts of Claims Act does not create any new cause of action against the state, but instead places the state on the same level in most instances as a private party. Stay out of them federal courts. The state is the place to sue the state. Like the scriptures say, if you and your brother have an argument or a disagreement and your brother did you wrong, then go to your brother and try to fix that wrong. And let him know his wrong against you. If he don't want to fix it, then you take your brother to a third party. And then that third party will intervene on your behalf. Same thing when you're dealing with these courts. If the state caused you injury, then you come to the state and say, man, look, you caused me injury. I'm filing a claim against you for the injuries you've done. If the courts of claims don't want to fix the injury, then you take it to the appealing court. Okay? But let's continue. Pursuant to ORC 2743.01A and ORC 2743.02E, the only defendant in the courts of claim is the state of Ohio, meaning that court is only made for you all to sue. For my people in Ohio, are only made to sue the state. The state is always the defendant in the courts of claim. And the state means if they are the defendants, then if you follow the rules of etiquette, then you get them to waive that immunity. Then you will collect the check. Why? Because you can see they are responsible for civil actions and money damages. But let's continue. Which includes the General Assembly, the Ohio Supreme Court, the Courts of Claims, the office of all elected state officers and all departments, boards, offices, commissions, agencies. I told y'all, child support is an arm of the state. So if child support is an arm of the state, it makes the child support agency a state agency that can be sued in the courts of claims if you are in Ohio. Okay? But let's continue. Institutions, colleges, universities, and other instrumentalities of the state of Ohio, in almost every instance pursuant to Local Rule 5 of the Courts of Claims and ORC 2743.03, a single judge or magistrate will hear a case, but the Chief Justice of the Ohio Supreme Court may assign a panel of 3 judges to a civil action that presents novel or complex issues of law and facts. Next chapter, immunity determinations. Pursuant to ORC 2743.02F, the court of Claims has exclusive jurisdiction to determine whether a state employee is immune from liability under ORC 9186. Therefore, pursuant to the holding of Johns versus University of Cincinnati, that's case law, courts of common pleas do not have jurisdiction to make immunity determinations until the courts of claim determines that a state employee is not entitled to immunity. Common plea courts are without jurisdiction over litigations against that employee. If a plaintiff wants to sue a state employee in his or her individual capacity in common pleas court, the plaintiff must first sue the state in the courts of claims and ask for an immunity determination pursuant to ORC 2743.02F. This where you sue the state at, not in federal court. They're telling you what to do, how to do it, and why you're doing it. This court is specifically made for lawsuits against the state. This court has jurisdiction to hear those matters once the state waives its immunity to be sued. Not the federal government. But let's continue. If the courts of claims determine that the state employee was acting within the scope of employment in furtherance of the interest of the state will accept responsibility for the employee's act, and the litigation may only be pursued against the state in the court of claims, not in the federal courts. No. But let's continue. See ORC 2743.02A2. However, if the courts of claims determine that the state employee was not acting within the scope of employment, the employee is personally answerable for his/her acts in the common pleas court. So now, if the state say, hold up, man, this don't fall underneath your line of duty. I ain't tell you to shoot nobody, but you shot him. Oh man, nah, you're going to jail and he's coming after you in the courts of claim. But let's continue. In Theobald versus the University, God, let me get out of here. In Theobald versus the University of Cincinnati, the Supreme Court set forth a two-part test for the determination of whether a punitive individual defendant is immune under ORC 986. The Court of Claims must first determine whether or not the person is a state officer or employee as defined by ORC 10936. If the court determines that the person is not a state officer or employee, the analysis is complete. ORC 1986 does not apply, and the Court of Claims would not reach the second part of the test, i.e., whether that person was acting in the furtherance of the interest of the state. Notable statutory provisions. I'm not going to go over all this. I'm just going to go over this first part, and then after the rest, you all can pause the video, read over it, get some understanding of what's going on, and that's going to be that. But it says, the state waiver of immunity is not unlimited. ORC Chapter 2743 provides a number of provisions unique to claims against the state. These common provisions include the following. You all can pause the screen and read over this. Okay? Alright, so I got to go. I got to get back to work. I got people I got to get to. I got people I got to make. I got a lot to do. But as I stated before, sue the state, end the state, stay out of those federal courts. It gets no clearer than that. I have more facts, more proof, more truth coming, more testimonies coming. We just waiting to hear back from these courts, and after that, we in there. Okay? So with that being said, you all need my help. Hit me up in my email at yahismagnified@gmail.com. If you all can't afford to make the donation or whatever, that's what these videos are for. These videos are giving more than enough remedy. Especially this video. This video is a gem. A gem. Giving away the game. Letting y'all all know where to sue, how to sue, and what to do to get your money back. And more. Way more than your money back. You can sue for at least $250,000. Okay? So with that being said, though, you all be blessed, man. Y'all have a good night. I have more informative videos coming. Shalom.